Good evening, everyone. My name is Michael Levinson. I am a senior consultant at Cirrus Consulting's healthcare leasing team, and I'd like to start off the presentation tonight just by thanking you all for taking the time to join us. We have doctors attending from across the entire country, so really looking forward to tonight's presentation. And the purpose of tonight's program is to discuss the concepts of estate and wealth protection, and to tie in how your practice and ultimately your lease agreement is integral to your success. The three tenets that we'll be addressing tonight are, number one, the value of your practice is directly correlated to the lease agreement that you have in place. There's a direct correlation. Number two, the sale of your practice is going to fund your retirement plan. And number three, reducing or eliminating your personal exposure protects you, your family, and your estate from unforeseen liabilities throughout your career. Now, before I go any further into detail, I wanted to give you a bit of background about us at Cirrus and our history, and give you a sense of who we are. So, we were founded in 1994 by a group of dentists who realized very early on in their careers that when it came to lease negotiation, they were really at a significant disadvantage. They were trained clinically and really had very little business experience or real estate experience, in particular with lease agreements specifically tailored for a dental tenant. Since then, we've analyzed over 1,000 leases every year. We negotiate about 500 of those leases every year. And since our inception, we've negotiated over 10,000 leases. We're growing substantially year over year. Additionally, we host hundreds of seminars across the country. We take part in many different dental associations and conferences. And of course, these presentations are very well regarded and CE accredited as well. So to give you a sense of some of the active files that we're working on, I had our marketing team put together this slide. And as you can tell, we operate throughout the country. And we're really the only player that understands real estate behavior in both large and small markets. And this is critically important because a landlord in Seattle, for example, is really drastically different from a landlord in New York City. So just to reiterate, the purpose of today's webinar is, again, to talk about how we can effectively set up the office lease agreement, which is really the most important document one of the most important documents that you'll be signing throughout your career, and how it correlates or how it directly influences your personal and professional wealth and how to structure it to protect your estate. So again, it's regarding the importance of the dental office lease, the key components that will help you grow, protect, and ultimately sell your practice. And we're going to talk about an action plan and discuss some practical tips for you to consider when developing your estate strategy and retirement strategy as well. So what is a lease? Now, we all have a general idea of what it is. Most people understand that it's a document that lays out the rent. It discusses who the rent is going to and what date the rent is due. And this is all correct. It's all completely true. There's one piece of paper that's more like a lease than you may have realized, and that's a check. And a lease agreement is the most expensive check that you will ever write, more than your car, more than all of your dental equipment, and more than your home in all likelihood. And interestingly, I was presenting a continuing education seminar in Beverly Hills a couple of months ago, and when I told a group of doctors what I just told you, one doctor stood up and, he looked a little bit upset at what I just said, and he told me, Michael, there's no way that the lease is more expensive than my house. Just not possible. And I asked the doctor, I said, doctor, how much money are you paying in rent? And, he took a step back and paused. And he says, well, my practice is prime real estate in Beverly Hills, and I pay $30,000 a month. And the crowd made some of their faces turned white. And now clearly, this is not a cheap lease agreement. $30,000 a month is certainly paying a premium. But I told him, doctor, let's assume that your rent never increases from today. And let's also assume that you're going to stay in this location for 20 or more years. So I started to do the math for him, and we worked out that there would be, it would be about $360,000 per year in rent. That's $3.6 million every 10 years, and that's $7.2 million over the next 20. And at that point, I think he understood that, what I was saying was actually correct. And interestingly, I mean, this math holds true for other dentists as well who pay a normal range of rent. For example, if you're paying $3,000 a month in rent, which is far closer to what's within the average, you may be paying more or less, then that math works out to about $36,000 a year. That's $360,000 every 10 years, $720,000 every 20 years, and $1,080,000 in 30 years of tenancy, which is not uncommon to practice for 30 years plus. So why is the office lease so important, and how does it influence estate planning and personal wealth? Firstly, there's investment and there's cost. Unlike most other commercial retail tenants, you being dentists have to invest hundreds of thousands of dollars into your space in the form of what's called leasehold improvements. Leasehold improvements are anything that's attached to a ceiling, wall, or floor that is not your trade equipment. So it wouldn't include things like your chairs and x-rays, but it would include things like the plumbing, the electrical wiring, the non-movable cabinetry, the dividing walls, things like that. So there's really a lot to consider when signing a lease agreement, because this investment needs to be protected long term so that we can receive a return on this investment. So what we do is we sign a long-term lease agreement. And a long-term lease agreement would typically be a 10-year term plus multiple 5-year options to extend. An option to extend is really just the ability for you to remain in the space without having to renegotiate the entire lease. The only thing that gets renegotiated is the rent, which is ideally tied to a market metric like the CPI, the Consumer Price Index, so that the increase is fair and reasonable and is relative to how strong the economy is growing at that time. And the reason why we look to sign a long-term lease agreement is because term gives you leverage. And the reason being is because this is what the landlord wants. The landlord, when you approach the landlord at the beginning of your term or even at the middle of the term, and you are looking to sign a long-term lease agreement, then the landlord is ecstatic, because you may not know this, but dentists are amongst the best retail tenants in the industry, because the default rate for dentists is actually less than 2%. The default rate for a restaurant is in the mid-80s, meaning that if you look at a restaurant down the street, chances are that within their 5 to 10 year lease agreement, they will have been late on rent or have defaulted on another provision in their lease agreement at least once. And if you think back, when you're driving up and down the street, it's really not surprising to see, restaurants changing over time. But really, landlords love dentists because they're rooted in their space. They invest in the space, and landlords know that they're not going to relocate. So we ask them for long-term because we enjoy it, because it provides us with longevity, and it provides the landlord with stability and rental stability long-term. And this leverage is used to get changes made in the lease agreement that protect our asset and provide us with flexibility down the line. So again, it's very difficult to move, given that it's we're not like dentists are not like, for example, accountants. Accountants, if they had to move, they really could move over the span of a weekend. They have desks, chairs, computers, whereas a dentist, it's really not quite as easy. It's obviously very time consuming as well. And the issue with dentists is if you have to close your practice to relocate, then that means that, number one, you're not making an income, and number two, there's patient attrition. Some of your patients may decide to go elsewhere, and some of those patients may not end up coming back. And lastly, the lease is critical for the practice sale. Without the lease agreement structured appropriately, then it is difficult, and in some cases impossible, to recover the investment in your practice and transfer the lease agreement and sell the business. So some of the benefits of a properly negotiated lease agreement is, number one, there's long-term stability and security, which we spoke about previously. Number two, there's a minimization of risk and exposure, and this really is a critical point. We talked about this as one of the tenets of the presentation tonight that we were going to speak about. And when I talk about minimizing risk and exposure, something that dentists are notorious at doing is giving what's called a personal covenant or a personal guarantee. And for those of you who have access to your lease agreements in front of you, I would ask that you look at the line item, usually at the very beginning, or sometimes at the very end where you're signing, and take a look at who is listed as the tenant. If the tenant is your name personally, you have given what's called a personal covenant. And what that means is that you are bound to the terms of this lease. And if excuse me, if for any reason you were to default on the lease, and that means being in breach of any of the provisions, including being late on rent, whether or not you were aware that you were late on rent, the landlord could recover damages from your personal assets. That includes your house, your car, anything that you own, and anything that your family owns. So it's absolutely critical that we do not give what's called a personal guarantee or sign personally. I would advise that each and every one of you have a corporation established, and how you set up the corporation will have some tax implications. So I advise you to seek guidance from either your attorney or your CPA, who will assist you with that. And the assets within that corporation should be minimal or ideally zero, so that if the landlord was to try and recover damages, they would be limited to the assets held within that corporation. Number three is to maximize your flexibility. This really is an important point, because we never want to feel bogged down or restricted because of the terms of the lease agreement. And there's one clause in particular that's particularly relevant to this point, which is called the associates clause or the assignment clause. So the assignment clause is the portion of the lease agreement, which we'll go into a bit of greater detail later on in the presentation. And the assignment clause dictates your ability to sell your business and transfer the lease agreement from one party to the other. So it's really critical that there's no inhibitors or hurdles that we have to jump through to go through with this process. Otherwise, it can make the sale of the business really a nightmare for some of our past clients. So it's critical that we straighten this language out as soon as possible. And to give you a sense, the assignment clause that we draft here at Cirrus is typically between 2 to 3 pages long. So if your assignment clause is 2 to 3 sentences long, what that means is that there's really not enough legal language there to protect you and provide you with flexibility. Within the assignment clause, there's a few things that we look for. Number one is what's called an associates clause. So typically what the landlord will do is they will demand that before you bring on an associate, also called a subtenant, the landlord must give their written consent. And for us to have to go to the landlord, for you to have to go to the landlord and get this consent, it can really hinder the ability to bring on really whomever you choose. I mean, at the end of the day, if you vet another dentist to bring on as an associate, that should be entirely your prerogative, and the landlord should have no say in the matter. So what an associate's clause does is it goes around that obligation and essentially just says, as long as the associate is clinically licensed in this state, then they should be entitled to practice there as well. Additionally, there's a section called the permitted use clause in some leases. It's just called the use clause. And what this clause stipulates is what you are entitled to use the space for. Oftentimes what we see is language stating that the tenant is permitted to practice dentistry, or they're permitted to practice a general dentistry practice. And although you and I know that within the umbrella of general dentistry lies all of the different specializations, a little bit of periodontics, orthodontics, prosthodontics, pediatric dentistry, et cetera, but the issue is from a commercial real estate standpoint, that's not necessarily the case. So what we need to do for this section is to be very clear and broaden the permitted use clause to very explicitly state all of the different specializations within dentistry. So just in black and white, list general dentistry, prosthodontics, orthodontics, et cetera, to include really any oral health and wellness specialization, again, that the tenant is licensed to practice in the state. And by doing that, number one, it gives you the ability to practice any type of specialty. So if you decide to learn implants or Invisalign or anything that may qualify as specialty work, you would be entitled to practice that specialization without being in breach of the lease agreement. Additionally, it would entitle you to bring on a specialist if you decided to without being in breach of this provision. And lastly, a nice barrier of protection is, I'll give you an example. We helped a doctor recently who had an orthodontist move in next door. So they were a general dentist, the orthodontist moved in next door, and to try and be a little bit more competitive, the orthodontist asked the landlord for an exclusivity agreement over all orthodontic work. Now, the general dentist practiced quite a few cases of Invisalign, and what happened was the landlord showed up at their door and gave them a letter saying the new tenant, the orthodontist, has exclusivity over all orthodontic work. And from this day forward, the general dentist would have to refer all of their orthodontic cases to the orthodontist. So the benefit of having all of these different specializations enumerated very clearly is that you would be entitled to practice all of these specializations and would not be susceptible to this exclusivity liability. Fourthly, a properly negotiated lease agreement ensures that there are fair and affordable financial terms. Ultimately, this will affect your wealth, obviously, and many of you have probably heard of a term called fair market rent. And for those of you who don't know, fair market rent, I mean, really what it means is that I, as a landlord, will get you to pay whatever I think I can get you to pay. That's fair market, because market rent is really whatever the tenant is willing to pay. And the issue is, for you as a dentist, you're essentially going into the process blind because you don't have access to relevant information. And what that means is that you're left in the dark to what is fair and reasonable. And you know, what about CAM? What about the common area maintenance fees? There's no way for you to verify whether the the taxes, the maintenance, insurance. I mean, how do you know if what you're being asked to pay is fair? And for the common area maintenance, what we do to mitigate this risk is we include a clause called a right to audit. And what a right to audit does is it gives you the ability to verify and validate all of these additional expenses. So the taxes, the maintenance, the insurance. And once implemented, often it's not uncommon that we find a discrepancy between what you've been paying or what you've been asked to pay and what you ought to pay. And what I'll do is at the end of this presentation, I'm going to be putting my email up. Some of you may have caught it at the beginning of the presentation. And if any of you feel as if you're overpaying in rent, send me an email, and I'll be happy to get our market analysts to take a look at the region and comparable spaces, and we'll help you determine if you're overpaying in rent. And lastly, a properly negotiated lease enhances your ability to sell your practice, whether you're planning on selling your practice in 30 years, in 20 years, in 10 years, or in 10 days. With all of the above mentioned properly included in your lease agreement, we can make your lease act as an asset instead of a liability. And when we represent buyers, what happens is they send us the prospective lease agreements to aid in the valuation of the practice. And if we get a lease agreement that's riddled with issues, I can tell you it severely diminishes the value of the practice, and it severely diminishes the desirability. So it's critical for the sale and for the maximization of the value of your practice that the lease agreement is structured properly. And when it comes to the value of the practice, there are really three saleable components of your practice. So three things that are part of the algorithm that determines the value of your practice. And those three items are the goodwill. And by the way, the breakdown is slightly different for specialists than it is for general dentists. But goodwill, simply put, goodwill is your active patient charts. So what is your consistent revenue stream? There's the equipment. And this would be the depreciated value of the equipment, not the value when it's brand new, as well as the leasehold improvements that we talked about earlier, so the plumbing, the electrical, the dividing walls, non-movable cabinetry, etc. And really anything that's attached to a ceiling, wall, or floor that you can't take with you when you leave. And once the first two items are established, the lease has to be transferred from the seller to the buyer. And the lease can determine up to 100% of the practice value, because if you can't transfer the lease due to onerous language, then what's the value of your practice? In fact, we're actually working with a doctor now whose practice is producing about $2.2 million every year, and they're currently a month-to-month tenant, meaning that they've run out of term on their lease agreement. They haven't formalized a new lease agreement as of yet. And right now, his chances of closing a deal are dead, because what's happening is, number one, prospective purchasers are looking at the lease agreement and seeing there's no term, and those who are interested, even without the term, are going to their banks for financing to finance the purchase. The banks are asking for copies of the lease agreements, and once the banks see that there's no term on the lease, they shut the door on the deal, because there's no bank in North America who will consent to hundreds of thousands of dollars of financing without term on the lease, because from their perspective, there's no assurance that there's enough term for them to amortize the cost of the loan and get paid back. So I wanted to talk about a few different items, a few different clauses that are in your lease. And for example, there's what's called the option to renew. And this is found in the vast majority of leases we come across, about 90% of leases. And we'll go through it line by line and kind of talk about the implications of what the language is. So feel free to read along. Firstly, what this says is, and sorry, allow me to take a step back. So an option to renew, as we talked about earlier in the presentation, is your ability to renew the lease agreement without having to renegotiate the terms. Really, the only thing that changes is the rent. And what this says is, provided that Dr. Joe Black shall remain as the tenant. And the issue with how this is worded is, when you sell your practice, you're no longer going to be the tenant. So if you're Dr. Joe Black and you sell your practice, what that means is that the new tenant, the prospective purchaser, will not be entitled to use the options to renew. And this can be a problem, because if you're on year 8 of a 10-year lease, same thing as like I just mentioned, the bank will take a look at the lease agreement, and if the bank does not see that there's exercisable term by the prospective purchaser, they shut the door on the deal, and the deal is dead. So we need to make sure that the options are transferable to the purchaser. And if the tenant duly and has regularly paid its rent and has performed its covenants and obligations under this lease and has not been in default. The issue with how this is worded is if the tenant has regularly paid its rent, and I imagine for those of you listening this evening, at one point or the other, the rent may have gotten lost in transit, the rent may have gotten lost in the mail, or you may have been late from time to time with or without your knowledge. And if the landlord wanted to make this process difficult, then they would have the ability to do so, saying that you've been late on rent, even without your knowledge. So in another section of the lease called the default section, we just need to make sure that if there is a breach, or if there is, for example, late rent, that you are made aware with a written notice so that you have record of this breach, and that you have a period of time to remedy this breach. It's what's called a cure period. And as long as we have that, then this liability can be avoided as well. Any such renewal shall be on the landlord's then current standard form lease. So standard form lease to a layman may just sound like, okay, the landlord has their standard form, and whatever that is, it'll be signed, and I'm sure it'll be fine. That's a lot of people's perspective on this language. And the issue is when it comes to a standard form lease, there's no such thing. The standard form lease is whatever the landlord puts in front of you. And the issue here is that if you go through hours of negotiation and structure a lease agreement that's favorable and fair and flexible, and you operate in your location for the duration of the term, and then it comes time for the renewal, and the landlord presents you their current standard form lease, you risk facing a lease agreement that's riddled with issues once again. So we need to make sure that the option is exercisable on the current lease, and that there's no changes made other than the rental rate. In no event shall the rent, it's referring to the rent, be less than the rent paid in the last year of the original term. And this really is a problem. We help a lot of doctors in Florida, and as you can, I'm sure, remember, a few years ago in Florida, there was a severe market crash, and we had some clients who had signed lease agreements at the height of the economy in 2006, early 2007, and they were paying a premium on rent. And you know the rest of the story. The economy tanked, and when it came time for renewal, their rental rate was well above market, but because of this language in their lease agreement, they were unable to get a reduction in rent. So we need to ensure that the rental rate for the option is based on fair market comparables. So not just the newest tenant in the space, because that could be a Starbucks who's paying a premium on rent, but that it's based on comparable dental practices within a given radius. And that way we have more of an apples-to-apples comparison. And again, this touches on the point that I just made, which is that it's based on market rent for renewing tenants in the building. If the newest tenant is a premium tenant, then the rent will be at a premium. We need to ensure that it's an apples-to-apples comparison, comparable with the dental practice and of comparable desirability, location, etc. Then there's the assignment clause, and this kind of problematic language is found in about 3/4 of the leases that we come across. And for those of you who plan on buying or selling their practice, this really will be the most important segment of the presentation. The sale of your practice, I would imagine, is a substantial contributor to your retirement plan and to your estate plan. So it's critical that this section is worded properly. And I just wanted to share a recent case that we were involved in with you. We were helping a 63-year-old dentist from San Francisco who had been in her building for over 35 years with the same landlord. She had treated the landlord and the landlord's family for many years, and knew them well. And this doctor's attorneys and advisors told her to sell the practice. And she formalized a conditional agreement of purchase and sale with a prospective purchaser. And the agreement had two conditions, which, by the way, we advise those of you looking to buy a practice to include as well. And these conditions were that the rental rates were not to increase upon transfer, which obviously affects the valuation of the practice and is fair and reasonable. And secondly, that the lease agreement were to be successfully amended and transferred from one tenant to the other to ensure that the new tenant is entitled to practice there and that there's no issues in the lease agreement. So this doctor approached her landlord and asked them what were the necessary steps to get the transfer process started, and the landlord told her that, you know, it's not a problem at all, and all she needed to do was to send him an email requesting the transfer of the lease. So she gets a reply email from the landlord asking, she sent the email requesting the transfer and gets a reply email from the landlord asking her to come to his office to talk about next steps with the process. And when she got to his office, she sat down and the landlord presented her with 3 different documents. Document 1 was a termination notice, effective immediately. Document 2 was a 30% escalation in rent. And document 3 affords the landlord 50% of the sales proceeds from the sale of her business. And she called us explaining her situation and got us involved in what was happening. And after more than 100 hours of back and forth negotiations with this landlord, the landlord just wouldn't budge. They were not willing to move. The landlord said, "You have to sign one of these agreements. There's no question about it." And what we were able to do, after hundreds of hours of negotiating, we were able to negotiate option 3, which was the percentage of sales proceeds going to the landlord, down to 25% from 50%. And with her practice appraised at $1.2 million, she ended up writing a check to the landlord for about $300,000. And as you can imagine, I mean, just a terrible situation. And I wanted to show you how in this language, how this can happen and how the landlord was able to do this. And funny enough, the landlord, after all this, was saying, I'm not a bad guy. It's just business. And what he was saying was that he's part of a group of owners who voted amongst one another that this was the best course of action. So he was kind of pushing off the blame from him to the group. But I wanted to go through this with you and demonstrate how this was achieved. So what this says is that if the tenant shall wish to assign or sublet the leased premises, the tenant shall first have received the consent of the landlord, meaning that you cannot sell your business without the landlord's consent. And this really means that they hold all the cards and they hold all the clout when it comes to selling your business. And we need to make sure that if the landlord wants this ability, which in some respects is fair, that there is sufficient governing language dictating why the landlord can disallow any sale of your business or transfer of the lease. Because in fairness to them, if you had a friend who wanted to open up a Pizza Hut and really liked your location, the landlord is within the rights to say no to that. But if you decide to sell your business to another licensed dentist, then the landlord should have no reason to step in and interfere. So, I mean, if a bank who is, one of the most difficult organizations in terms of credentialing who they lend money to, if they're willing to finance a loan 100%, then really the landlord should have no issue with consenting to an assignment. It goes on to say that the landlord shall have the option to either terminate the lease or to revise the minimum rent to be paid during the remainder of the term to the greater of the then current market rent for the lease premises, or 15% greater than the then current rent. So what this is saying is that if you give the landlord written consent, as this doctor that we're helping did, then the landlord has the ability to terminate the lease, and at that point, all leverage is gone. And really, they can do whatever they want. They can ask for an increase in rent. They can ask for a percentage of the sales proceeds, because the alternative is that the lease is terminated and you have nothing to sell. So really important that this language gets changed as well. And lastly, what this says is that the tenant shall not be released from its obligations under this lease and shall remain liable for any failure of the tenant or its assignees or subtenants to observe each and every covenant of this lease. In the real estate industry, this is what's called ongoing liability or continued liability. And what this essentially says is that if you go through the proper channels and you sell your business to another doctor, then the new tenant, that you will still be liable even after you've sold the practice. And we were helping a doctor out of Detroit, Michigan, who had this clause in their lease as well. And they had sold their practice to a younger doctor, and a couple of years into their retirement, they had got a call from their old landlord, and the landlord let them know that the new doctor had defaulted on their lease. They had not paid rent for the past 6 months. And the landlord's expectation was that this retired doctor would pay him for those outstanding 6 months of rent, and also would be on the hook for the remainder of the term, which at that point was about 7 years. So this doctor called us explaining the situation, and we requested a copy of the lease agreement, and we saw that he actually had this ongoing liability. And what this meant is that him and his estate were liable. There's no two ways about it. He agreed to this liability. So to try and help him, what we were able to do is we were able to identify another dentist to take over the space, but it took us about 4 months or so of searching. So at the end of the day, he was left footing the bill for about 11 months or so of rent for a practice he had nothing to do with anymore, and it just ate into his retirement savings. So critical that when the lease gets assigned, that the liability should be assigned as well. And completely transparently, there are some landlords who are not comfortable with this, and in situations like that, the risk mitigation tactic that we implement is that the ongoing liability should be limited to a short period of time, whether it's a few months or a year and a half, whatever that period is. But to have you liable in perpetuity is really unfair liability for you and your estate. So there really are a laundry list of items that are critical parts of the dental lease that influence the value of your practice and aid in estate planning. And in the interest of time, I'm not going to be going through all of these, but there is one item that I wanted to highlight on this lease, which is located on the left side here, the third item called relocation. Relocation really it's a catastrophic event for any dentist. Relocation is the landlord's ability to obligate you to relocate your practice to another space in the building or in the plaza. Because on occasion, the lease will say that the landlord will pay for the movement of the current location to the next location. And really, what does this mean? It's, the landlord's going to pay for the movement from one location to the next location. From our experience, this can mean that the landlord will hire movers and physically move all of your equipment to the new space. However, what it does not include, that they won't pay for the plumbing build-out, the electrical, the dividing walls, nothing at all. They will literally pay for strictly the movement. And as you can imagine, really this is it's one of those clauses that it's a huge deal breaker if you're trying to sell your practice, number one. And number two, if you are the tenant, it's a tremendous liability. I mean, imagine if you were looking to buy a practice for hundreds of thousands of dollars, sometimes over $1 million, and there was a risk that with a 30-day notice, the landlord can obligate you to relocate the practice to another space in the building. I mean, number one, it would cost a fortune. Number two, your practice would be closed for 4 or more months building out the space, not to mention the demolition of the current space. And number three, the space could be in a much less desirable location. You might be in prime real estate with lots of frontage and foot traffic, and the landlord may want to relocate you to a location with less frontage, less signage, next to the dumpster. And there's no saying as to what rights you have as a tenant. So it's important that we have that enumerated as well. And the relocation clause ideally is eliminated, but if the landlord is adamant on including, and for your knowledge, the reason why landlords like to include a relocation clause is because if a premium tenant, for example, a Starbucks comes along and says, I love Dr. X or Dr. Y's location, and they're willing to pay a premium, the landlord wants the ability to relocate you so that they can benefit from that increase in rent. But our standpoint is if this is going to be the case, then the landlord needs to pay for everything, for absolutely everything. There needs to be minimal downtime so that the practice needs to be built out and ready to go over the span of a weekend so that there's no downtime, there's no patient attrition. When it comes to desirability, we need to have control. And when it comes to square footage, there needs to be appropriate square footage as well. So, for example, if we're currently in a 1,500 square foot box, and the landlord wants to move us to a 1,000 square foot box, then we may have to lose an operatory or two. And conversely, if the landlord wants to move us to a 2,000 square foot box, then we may end up paying for space that we may not need. So there's really a whole host of factors that need to be included in this provision. If it is included, ideally we'd like to remove it because, as I mentioned, it really does severely impact. If worded improperly, it severely impacts the saleability and desirability of your practice. The biggest issue that dentists have relating to their lease agreements is that they wait too long for addressing them, and it really is critically important to estate plan and to plan on commencing the lease negotiation process likely earlier than you may be expected to. It takes on average about 6 months to move a dental practice, and landlords know this, and they use that to their advantage because if you get to a point where, let's say you're 8 or 6 months away from expiry, there's really nothing stopping the landlord from presenting you two different options, a 40% rent increase or a termination notice, because what the landlord knows is that with 6 months remaining on the term, there's no possible way that you'll be able to source another location and either buy a built-out practice or build out a practice. It's just very unlikely. And even if you were able to do it, landlords know that it's very costly. So one of the most important things that I can impart on you today is that the process should begin ideally about 24 months out. And that the reason being is because landlords are experts at delay tactics. If you were to approach them and ask for the lease agreement to be addressed, they cite that there are tenants expiring more imminently than you, and they want to address that. They cite that they're busy, that they're going on vacation, and before you know it, there's 9, 8, 7, 6 months left on the lease agreement, and at that point, the landlord's got you. So time is really critical, and it really is important that even if the landlord says, come back to me in a couple months, that process has started. And as time progresses, we can turn up the heat, so to speak, and instill a bit more pressure. Now here at Cirrus, when it comes to the lease agreement and the lease negotiation process, there's a 7-step process that we follow. Firstly, we gather all of the documentation. So make sure that you have the lease agreement and any ancillary documentation such as any addendums, any riders, any extensions, estoppels, all of the above. And we conduct our due diligence, including a thorough review of all of those mentioned documents. And essentially what we do is we highlight all of the risks. So comb through the entire lease agreement and see whether or not any of those liabilities are present. In addition to highlighting those risks, we conduct some market analysis, including vacancy rates, rental rates, to help us address the financial aspect of the negotiation, such as the rental rate, any sort of tenant inducement allowance. And when it comes to the rental rate, although it's something that you feel every day, ultimately it will have an effect on the valuation of the practice as well, because if you're overpaying in rent, then it diminishes the number one, the desirability, and secondly, the eventual sale price of the practice as well. Once we've addressed the risks and the market analysis, we develop a custom strategy based on the specific needs and the life plans of the client. So if you're a new dentist, if you're a mid-career dentist, or if you're looking to transition, that will affect how the language is structured. For example, things like the term, things like the assignment clause, etc. At this point, we contact the landlord and we begin negotiating the financial terms of the lease. It's always the very first thing that we address, because this is what matters the most to the landlord. And typically it takes around 8 to 12 weeks. And once we finalize the finances, which again, the landlord cares about most, at that point we can focus more on the legal language and the liability, which we really care about most. and without having to worry about movement on the finances. And again, once the financial terms are agreed upon, we spend considerable time negotiating the legal terms, including many of which I covered in previous slides. And finally, after the legal and financial terms are solidified, we review the lease once more. And the reason why we do this is because we've gotten to the stage more than once when the quote-unquote final document they send off is just a copy of the original lease. It's the very first lease that we began the process with, without any of the negotiated changes. So after back and forth, they send us this original lease. And landlords love to blame this on their admin staff. They say it was a mistake, they didn't realize. And you can, I'm sure, can imagine the reason why they do this is because they want to make sure, they don't want to make sure, they want to potentially have the tenant sign the lease without reviewing it, and that way they have all that language that benefits them greatly. And once the lease is signed by both parties, so we ensure that the I'm sorry, I'm just having some issues with my computer. Once the lease agreement is signed by both parties, we actually digitize the lease agreement, and we keep a copy on record so that we can help support you on an ongoing basis, by alerting you of any upcoming expiration dates or deadlines to issue extensions of the lease agreement. So the key takeaways today are that there are details in the lease agreement that can cost hundreds of thousands of dollars if left unchanged, and really they can have a significant impact on the valuation of your practice and ultimately your retirement savings as well. The rent is important, especially when it comes to the sale value of the practice, but it's not only about the rent. The legal terms which we talked about can cost you hundreds of thousands of dollars in liability, and again, really can hinder or can drastically impact the ability for you to sell your practice in the future. What we focus on is the minimization of risk or elimination of risk whenever possible, and the maximization of flexibility. And these two things will make your life in the practice much more comfortable, and will remove any sort of liabilities that you have. You'll be able to sleep very well without any of these issues, and again, makes the practice easier to sell. It's really important to be strategic. If you don't know what to ask for, and if you don't ask for it, you won't get it. The landlord has zero incentive to be proactive in changing the lease for you. So if you don't ask for it, then it's done. And to start the process early, again, 24 months is ideal. And lastly, it's important to do your homework and have some research. It's important that if we're going to talk to the landlord about the rental rate, that we come equipped with market data. And we farm that data from some resources that we at Cirrus, we pay thousands of dollars a year to have access to, but that gives us some science to back up our requests, so that if we're going to the landlord, rather than saying we feel as though the rent is too high, we can demonstrate that X, Y, and Z are paying A, B, and C in rent. So it makes that conversation much easier to have. I want to thank you all for attending this evening. I'm going to be sticking around and posting a screen in just a moment for some Q&A. I'm happy to answer any questions you have. But what we're doing is we're actually extending an offer this evening. So the first 5 doctors that can send me an email just listed below to mlevinson@cirrusconsultinggroup.com, we're going to be extending an offer for a complimentary lease analysis. So typically, we charge $1,495 to review one's lease agreement and assess it for any liabilities, but we're actually going to be waiving that fee for the first few doctors that request it. So feel free to extend that email, or if you have any questions, you can stick around, and I'll be here for the next few moments. So once again, I want to thank you all for attending, and if you have any questions, I'll be popping up the screen any moment now. Thank you.